Welcome back to the virtual orientation for incoming students in the English Language JD program at the University of Ottawa. In this podcast, I converse with Professor Adam Dodick about the Canadian Constitution. And we examine exactly what it is that constitutions do, what the Canadian Constitution consists of, and why it's important for you to understand this foundational document in Canadian law. I began by asking Professor Dodick about his career and background in law.
My name's Adam Dodick. I teach the first year course in public law and legislation. I teach an upper year seminar on the Supreme Court of Canada, and I teach a first year thematic in legal ethics and professional responsibility, and I also serve as the Vice Dean of Research of the Common Law program.
And you had a career before joining academia as well, didn't you, Adam?
Yes, I did. I spent some time in private practice, both in California and in Toronto, and I worked in government as a senior advisor to the Attorney General of Ontario, and I clerked in 3 courts in 3 different countries: for the Supreme Court of Israel, the U.S. Court of Appeals for the Ninth Circuit in Pasadena, California, home of the Rose Bowl, and at the Supreme Court of Canada for the Honorable Claire Leroux Dubé.
I want to focus our conversation today on the public law aspect. Of course, you teach public law and legislation, and focus specifically on the idea and content of the Canadian Constitution. Let's begin by just discussing why a Constitution is important.
I think a Constitution is important for many reasons. First of all, a Constitution, I like to consider a Constitution, the Constitution is the foundational law for a country. It's one way that I describe it is the rule book for the operation of government, and it also expresses the fundamental values of a country. So it expresses who we are as Canadians, and it also tells us a little bit about how government works and the relationship between government and citizens.
And so where does the Constitution come from, thinking specifically about the Canadian Constitution?
Well, our Constitution, we weren't born in revolution the way that the United States was. And our Constitution was actually originally an act of British Parliament in 1867, what used to be called the British North America Act. And then there was a long process of trying to make the Canadian Constitution wholly Canadian. And there's a special word for that. It's called patriation, which really only exists to refer to that process of taking a British statute and converting it into a Canadian Constitution, and that happened in 1982. So our Constitution is made up of a number of documents, a number of statutes, and we now refer to the original Constitution as the Constitution Act 1867 and the new Constitution as the Constitution Act 1982.
And so these documents that constitute the Canadian Constitution, are they the only source of constitutional law?
No, in Canada, we have what we refer to as the written Constitution, which is the law that is written down in these statutes, and we also have unwritten aspects to our Constitution. And so we actually refer to an unwritten Constitution, and that consists of practices, values, and agreements, informal, unwritten agreements that have taken place or that have grown up over time that political actors abide by, and we would say are part of our constitutional law.
And so can there be uncertainty as to the precise scope of the Canadian constitutional law?
Well, absolutely. I mean, there are some things that are very precise, as far as in order to be a senator, you have to own property worth $4,000 in a certain province. You have to be at least 30 years old. Those are examples of things that are very specific, and we know for certain. There are other things that are more uncertain. Section 7 of the Canadian Charter of Rights and Freedoms says that everyone is entitled to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. So we continue to struggle with the exact scope of what is liberty, what is security of the person, etc.
How has the Constitution changed?
We have, our Constitution has changed, I guess, in a number of ways. We have a formal amendment process, which is set out in the Constitution if you actually want to change a provision of the Constitution. And there's a number of different ways to do that, and that involves government, that involves the Parliament of Canada, meaning the House of Commons and the Senate, and it may involve the legislative assemblies of particular provinces or of all the provinces. But there's also a process of more gradual change, where the meaning or the values that are protected under the Constitution can change over time, can expand or contract over time in accordance with changing values in Canadian society.
And so, to the extent that the Constitution is interpreted and reinterpreted in the manner you just described, does that take place in front of courts?
Often it does. The Constitution sets out that the courts are the ultimate arbiter and decider of the Constitution. And some of the most important things will eventually make their way all the way to the Supreme Court of Canada for a final and definitive determination in most cases. But there are other things that, again, that the change may be a change in practice by the political actors or a change in practice by the Legislative Assembly, and things that just change over time.
One of the aspects of the Canadian Constitution, one of its most famous aspects, is the concept of division of powers or federalism. What do we mean by that?
What we mean by that is that power in Canada is divided between two levels of government. We have a federal state, and what that means is that we have two levels of government. We have a federal government for Canada as a whole that is situated here in Ottawa, and we also have provincial governments located in each of the 10 provinces, and then we have 3 territories. Other countries, the United Kingdom used to be a good example of that, where there was only one government. There weren't provinces, there was just a central government in London, and we, like the United States, have a federal system where power is divided over certain subjects between the federal government and the provincial government.
And so how does our Constitution do that division?
Well, that's always been one of the most important aspects of our Constitution, going back to 1867. So we have 2 sections of our original Constitution, the 1867 Constitution, which actually list, here are the powers that belong to the federal level of government. Here are the powers in a different section that belong to the provincial level of government. So very much part of an important, and I would say a dominant theme in our country's history, and in particular our constitutional history, has been the division of powers. We also refer to that as federalism, about the relationship between the federal government and the provincial governments. Essentially, who can legislate or who can make a law over a particular subject matter.
One of the other things our Constitution does, presumably, in creating this federal system is it also establishes the institutions that comprise Canadian government. There's this concept that you hear talk of known as the different branches of government. What do we mean by that?
Well, the term different branches of government is a descriptive term that we use to describe the different features of government. So typically we refer to 3 branches of government. We refer to a legislative branch of government, we refer to an executive branch of government, and a judicial branch of government. The legislative branch is the branch of government that is primarily responsible for making laws. So federally, the legislative branch is the Parliament of Canada, which consists of the Senate, which is an unelected upper house, and the House of Commons, which is an elected lower house, as well as the Queen or the Governor General has some formal role in that. The executive branch, which people might be familiar with as the Prime Minister, members of Cabinet, but also would include the public service, ministries, departments, etc. They're responsible for administering the laws. So they don't actually make a new law, but Parliament would pass a law, and they're responsible for administering it and making sure that it goes into effect. The third branch, the judicial branch, is also known as the courts, and they're responsible chiefly for interpreting those laws as well as adjudicating disputes between different parts of government and adjudicating disputes between citizens and their government and disputes between individuals and generally disputes between citizens in the country.
One of the unwritten constitutional principles that's held this system of branches of government together is known as parliamentary supremacy or parliamentary sovereignty. What is that talking about?
That's talking about the idea that basically Parliament is supreme. Parliament can make any law that it wants. I think it was Winston Churchill who famously said that Parliament could declare Sunday to be Thursday and evening to be morning, etc., and there was no recourse to that. We've always had a limited system of parliamentary supremacy because of the division of powers that you asked me about before. In 1982, our system of parliamentary supremacy was further limited with the enactment of the Canadian Charter of Rights and Freedoms. And what that did, if that really changed our system, changed our Constitution, because division of powers was a limit on which level of government could pass a law. But it didn't say that there were types of laws that no government could pass. The enactment of the Canadian Charter of Rights and Freedoms changed the constitutional equation by saying that there are some laws that no level of government can pass. So the example that I gave you before about Section 7 of the Charter protecting the right to life, liberty, and security of the person, if a court determines that a law or an action of government at whatever level violates that provision of the Charter and is not justifiable under a different section of the Charter, then that law is invalid and no level of government can enact that law.
In a system of parliamentary sovereignty curtailed in the way you've described, isn't it the case that the Prime Minister can simply tell parliamentarians what to do? Is that the system that we have? Isn't that what we gather when we read our newspapers?
Well, a lot of people may have that impression, but the Prime Minister, like every citizen in the country, is subject to the law. And that is gets back to another important unwritten constitutional principle, which is the rule of law. And the rule of law is multifaceted. There are different elements to it, but one of the most important elements to it is everyone is subject to the law. Whether it's the Prime Minister, there's a great phrase that I love of, you can be, a king or a street sweeper, but everybody dances with the Grim Reaper. And that's the essence of the rule of law. It doesn't matter how rich you are, how poor you are, what position of power you hold in this country. You only have the power that is given to you under the law, and everyone is subject to the law. So for the Prime Minister, the only reason why the Prime Minister has any power whatsoever is because he or she has the confidence of the elected branch of government. That means that the people that we as Canadians elected to the House of Commons, a majority of them support the actions of the Prime Minister. If they no longer do that, whether that's by voting non-confidence in the government and the Prime Minister, or whether that's by the results of elections, then the Prime Minister can no longer continue as the Prime Minister.
And so, in other words, the Prime Minister persists in his or her office essentially at the pleasure of the elected members of the House of Commons?
That's correct. And if the elected members of the House of Commons, who we as Canadians elected, decide that they can essentially fire the Prime Minister. Now, that is rare in our system of government to happen, but it's important to understand that the source of all of the Prime Minister's power comes from that vote of confidence and that process from our elected House of Commons. And the same process would occur on the provincial level for premiers of provinces and the relationship between them and their legislative assemblies.
Let's talk about the third branch of government, the judiciary, which you mentioned before. There's yet another unwritten principle of the Constitution, although it does have some textual reference in the written portions of the Constitution, known as judicial independence. What do we mean by judicial independence?
I guess what we mean by judicial independence is that the judicial branch, the courts, both as a collective entity as well as individual judges, have to be independent from the other branches of government. They don't take orders from parliamentarians, and they don't take orders from the Prime Minister. And a good example of that is thinking about the lack of independence and how that would look. And in other countries that don't have judicial independence, don't have an independent judiciary, another phrase that we use, there's something called telephone justice, where a minister or a senior official might call up a judge and say, "This is how I want you to rule in this case." And that's a very direct example of the lack of judicial independence, but there are more indirect examples. In another country, in a controversial case, the Chief Justice of the highest court in that country was summoned to the president's residence. And when he showed up at the president's residence, he was met by the president in full military attire, surrounded by 5 generals. Not much was needed to be said because the message of intimidation was quite clear. So for us, when we talk about judicial independence, we mean sufficient independence from the executive and the legislative branch of government so that our courts can fulfill their fundamental role. And the basic role of the courts in a democracy and in Canadian democracy is to make decisions without fear or favor towards any of the parties to the dispute. Canadians have a right to unbiased decision-making. And so the idea of an independent judiciary is in order to insulate the courts to ensure that judges can fulfill that role and that all Canadians can have the benefit of fair and impartial decision-making.
And so how do we preserve that judicial independence in practice?
We preserve that judicial independence in practice through a number of ways. We set the judges apart from the other branches of government. Our Constitution, our original Constitution in 1867, set up a number of ways in which judges were created to be independent. The first is security of tenure. So when judges are appointed, and judges at the federal level are appointed by the Prime Minister or by the Minister of Justice, when they're appointed, they're appointed for life. They have to retire at mandatory retirement age at 75, but they cannot be fired or suspended except through a process which is laid out in the Constitution and in legislation. They cannot be summoned to explain their decisions if the government doesn't like them. They can't be suspended. They can't get a bonus if they issue decisions that the government likes. And so the first thing is security of tenure. And with that is also protection of their remuneration and their salaries, which is that all judges are paid generally the same level, depending on which court they're at. And again, there's not a bonus or a decrease if their decisions find favor or annoy the government. And there's a rigorous process that has been set up in order to ensure that the process of determining judges' salaries is as non-political as possible. We also give a lot of autonomy to the judicial branch in administering the courts. So only judges or their staff can determine which judges are going to hear which particular cases, and judges determine the scheduling of courtrooms and where a judge is going to, what city or what courtroom a judge is going to sit in. Because again, you could see that if the government controlled those things, then the government could decide to assign a judge who they perceive to be favorable to them to hear a particular case, and the government could punish a judge who they didn't like by sending them to a remote area to hear cases. So those are just some of the ways that we have protected judicial independence and set up really a separation or a protective barrier between the courts as an institution and the other two branches of government.
So we've been talking about constitutional law, and constitutional law is a subset of public law. What else do we include within the category of public law?
Well, for the category of public law, what we mean by that in the broadest sense is the entire area of law that relates to different institutions of government and the relations between them, and the area of law that relates to the relationship between citizens and their government. And constitutional law is perhaps one of the biggest areas of that. Administrative law is a very big area, and administrative law relates to I talked before about the process in which, that the legislature makes the law, and often in legislation, various administrative bodies are created, and we have thousands of agencies, boards, and commissions, from the Canadian Wheat Board, the Immigration and Refugee Board, the CRTC, which regulates television, radio, cell phone usage, things like that. So the law that deals with the decisions of all of those administrative bodies is known as administrative law.
And so if a student were interested in public law, where would they be exposed to public law in the first year program, and how could they be further exposed thereafter?
Well, I think that we believe that here at the University of Ottawa we've got the strongest public law program in the country. Our students take the mandatory first-year course in public law and legislation in their first semester. They take Constitutional Law 1 in their second semester, and then in their second year they take Constitutional Law 2, and in their second or third year they have to take Administrative Law. So those are the four mandatory foundational courses for public law. And then after that, we have over 30 members of our public law group that collectively teach probably 60, 70, 80 different public law courses. So there's many specialized courses dealing with government lawyer, dealing with securities regulation, tax, all different sorts of areas of public law.
How else can a student get involved in public law here at the university while a law student, other than taking courses? Are there opportunities extracurricularly?
Well, there are formal activities extracurricularly in terms of there's a Public and Constitutional Law Students Association. There are many activities that we have at the law school where we bring in speakers. We're in the public law capital of the country, and we really try and leverage that. But there's a lot of things that students can do on their own. So they can go to the Supreme Court and watch cases. They can go to the federal court. They can go to the Superior Court. And I've had a number of students over the years that have gone to watch cases and see some of the best lawyers across the country come to the highest court in the land to argue the issues of the day.
Thanks very much, Adam.
Thank you.